Are both parties present and ready to proceed?
Yes, Your Honor.
Okay, we ready to hear opening statements?
Before we begin with opening statements, Your Honor, the plaintiff would like to introduce themselves.
Okay.
Good morning. My name is Nia Boyd, and I'm a plaintiff attorney on behalf of Ethel Marks. I am accompanied by my second chair, or my co-counsel, Sebastiana Emil, who will largely be off screen for most of the time, but assisting me with the technical issues of today's trial.
Okay. Defense counsel, will you make appearances for the record as well?
Of course, Your Honor. Good morning, Your Honor. Luke Morales for the defendant, Sonny's Rooftop Bar. Today I'm joined in court by defense's second chair, Ms. Corinne Loya.
Good morning, Your Honor.
Good morning.
Your Honor, that's all the introductions from the defense for this morning.
Okay, are we ready to proceed with opening statements?
Your Honor, before we proceed, defense has a few preliminary matters we'd like to address before trial begins.
Okay.
Your Honor, first, defense would like to note that pursuant to local rule 9D5, exhibits need not be shown to opposing counsel before being shown to the witness during examinations.
Can you say that one more time? I'm not sure I was following you.
Yes, Your Honor. Pursuant to local rule 9D5, a rule in our local jurisdiction, showing a witness to opposing counsel before showing it to a witness during an examination is not required.
Showing an exhibit to opposing counsel, showing an exhibit to opposing counsel is not required.
Before showing it to a witness, that's correct, Your Honor.
Yeah, my assumption is that both of you have seen the materials in the joint exhibit list, and so to the extent that you're showing a document on the joint exhibit list or a transcript of a witness's prior testimony, I can assume that you both have seen that stuff.
Yes, Your Honor. Your Honor, defense would like to also invoke Rule 603. This would constructively swear in all witnesses prior to testimony.
You're all sworn, don't lie. What's next?
We would finally like to invoke Rule 615. Your Honor, this would constructively sequester all witnesses in today's case, with the exception of a party representative. The defense would like to designate Sonny Mehta as a party representative for the defendant here today.
Ms. Boyd, any objection to that?
No, Your Honor.
All right.
Your Honor, that's all the preliminary matters from the defense.
Your Honor, I just have a few questions just based off of the technological aspects of today's trial. Would you like for the record to reflect, or would you prefer for us to ask for permission to share an exhibit?
I'm not sure I understand.
So when we're going to share something with the jury, would you prefer for us to say, let the record reflect that my co-counsel is sharing, or Your Honor, we would like to share an exhibit?
You don't need my permission to display anything that's been admitted, but to the extent that something is not admitted, number one, I don't think you should be displaying that until it's admitted. But if you're going to, for some reason, ask my permission before you just show the jury something that's not been admitted into evidence. Does that make sense?
Yes, Your Honor.
Okay. What I'm trying to say is, to the extent that you've offered a document or an exhibit into evidence, and the court has accepted that document into evidence, and you want to put that on the screen, you don't need my permission to put something on the screen that's already been admitted into evidence. But if it's something that's not been admitted into evidence, or accepted by the court into evidence, then ask permission first, and we'll deal with it at that point. Does that make sense?
Yes, Your Honor.
Okay.
Thank you.
Anything else?
No, Your Honor, that would be it.
Okay. Are we ready to open?
Yes, Your Honor.
Okay. So we're going to hear opening statements from the parties now, and I'd ask that the attorneys who are not giving the attorney who's not giving the opening statement turn their video off during their opponent's opening statement. Ms. Boyd, whenever you're ready, you can proceed.
Let's give me 1 second. Sorry. I'm sorry. Okay. May it please the court. They knew the law, but they ignored the law. A severe brain bleed, broken ribs, multiple skull fractures, her body twisted and contorted in a car at the bottom of a ravine. This is exactly what happened to Jessica Marks, who died on March 24th, 2019. And this happened because the defendant knew the law, but they ignored the law. My name is Nia Boyd, and I'm a plaintiff attorney representing Ethel Marks, Jessica's mother. Today, the plaintiff has a burden of proof. We have to prove to you by a preponderance of the evidence that, which is just more likely than not, at Sonny's rooftop bar, knew Jessica was obviously intoxicated on March 24th, 2019. And we're going to prove this to you with two important facts. They knew the law and they ignored the law. Now, in today's trial, you'll hear about the history of Sonny's rooftop bar. You'll find that the defendant had a history of breaking the law. A history that would affect Jessica Marks's life on March 24th, 2019. Because this history will show you with testimony that they knew the consequences and they knew what should have been done. But they didn't. You'll also hear today that they knew the obvious signs of intoxication. The defendant was aware that they were supposed to be looking for visual and auditory cues. But I also want you to listen to the testimony that comes from Sonny Mehta in today's trial. Because you'll also hear about how they knew about tolerance that came with owning the bar. You'll hear how height and weight both affect someone's tolerance. Members of the jury, you're going to hear how a 5 foot even girl walked out of the defendant's bar with a blood alcohol content of 0.16 the night of March 24th, 2019. Now in today's trial, two witnesses will take the stand. Morgan Levin and Sonny Mehta for the defense. But I'm going to come at the end of today's trial and ask you to find the defendant, Sonny's rooftop bar, liable. Because they knew the law, but they ignored it. Thank you.
Thank you, counsel. Mr. Morales, whenever you're ready to proceed.
Yes, Your Honor. One sober bar owner, one tipsy customer, but both had the same story. Members of the jury, today the plaintiff has filed a claim of wrongful death against Sonny's rooftop bar, a claim that they violated section 25602.1 of the California Business and Professions Code. Members of the jury, I want to be very clear about what that means the plaintiff must prove in today's case. They must show that 1, Jessica Marks was served alcohol while Sonny's rooftop bar knew she was obviously intoxicated. And 2, that the drinks Sonny's rooftop bar served her, members of the jury, while she was obviously intoxicated, were a substantial factor in her death on the night of March 24th. Members of the jury, there's 2 questions I'd like for you to keep in mind in today's case, as the evidence is presented over the course of today's trial. When did Sonny's rooftop bar realize that Jessica Marks was under the influence? And 2, how many drinks was Jessica Marks served while the defendant knew she was obviously intoxicated? At the end of today's trial, you'll find that Jessica Marks was served 0 drinks while she was obviously intoxicated. and that the plaintiff's entire case is based on the eyewitness testimony of an individual who was considerably under the influence on the night of March 24th. Today, you'll hear from Sonny Maida, the owner of Sonny's Rooftop Bar. He'll tell you that he was serving Jessica and Morgan the entire night, and that once Jessica Marks never looked intoxicated to him. He'll tell you that Jessica was understandable, that she was coherent. He'll tell you that Jessica Marks looked okay right up until the very second she walked out of his bar on the night of March 24th. Members of the jury, Mr. Maida will also tell you about who didn't look okay that night. Morgan Levin, the sole witness for the plaintiff in today's case. She'll tell you about how Morgan Levin was displaying all the telltale signs of intoxication that she's seen as a bar owner. She'll tell you that she even asked Jessica Marks if Jessica was going to drive home because she was worried about Morgan. You'll hear that an eyewitness, Stevie Rager, actually said that Morgan was wobbling around like she'd been in the ring with a boxer, and that she could barely walk in a straight line towards her Uber at the end of the night. Members of the jury, today the plaintiff bears the burden of proof in today's case. More likely than not. They must prove all elements of their claim to be more likely than not what happened on the night of March 24th. Members of the jury, today you'll learn that while Sonny Maida was sober, and that while Stevie Rager was intoxicated, the both of them had the same story about Morgan Levin's intoxication and Jessica Marks' sobriety on the night of March 24th, 2019. Members of the jury, what happened to Jessica Marks was a tragedy. But by the end of today's trial, the law will demand that you find Sonny's Rooftop Bar not liable in today's action. Thank you.
Thank you, counsel. Ms. Boyd, call your first witness.
Yes, Your Honor. The plaintiff would like to call Morgan Levin to the stand.
Proceed.
Good morning, Ms. Levin.
Good morning.
Could you please introduce yourself to the court?
Yes, my name is Morgan Levin.
What's your current occupation, Ms. Levin?
I am a college student studying biology at UCLA.
And why are you here today?
About 2 years ago, my friend Jessica, she died in a car crash. I'm here today to discuss the events that led to her death.
Before we get into what happened to Jessica, I want to learn more about her. What was she like?
Well, we met in 2013 in high school back in Pennsylvania and immediately clicked. We had so much in common, like the same birthday, similar interests. She was such an amazing person. I mean, we listened to music, watched Netflix, hung out all the time. She was so full of energy and life.
Earlier, you mentioned that you were in college. Did you and Jessica go to the same college?
No, she got into Drexel University studying pre-law, but we always make sure that we have time during breaks to visit one another.
Ms. Levin, I want to talk to you about March 24th. What did you do?
Well, at around 9 p.m., we went to Sonny's Rooftop Bar.
Who's we?
Jessica and I.
Why did you choose to go to Sonny's Rooftop Bar?
Well, a bunch of my college friends said that Sonny's Rooftop Bar is a good place to drink and we wouldn't get carded.
Objection, Your Honor, hearsay.
Response?
Yes, Your Honor. This was a reputation that was established within Sonny's Rooftop Bar, which is admissible under Rule 803. for the exceptions of hearsay.
Your Honor, may I be heard?
Sure.
Your Honor, I believe the exception to reputations in a community, in a community under a rule of evidence 803 goes to just that, a community. The witness testified that a few of her college friends told her that Sonny's rooftop bar served underage people. Your Honor, that doesn't meet the bar of what a community is. This evidence that the witness is presenting is not admissible under the community exception.
Sustained.
Your Honor, motion to strike any testimony the witness may have made about Sonny's rooftop bar.
I'll strike the witness's answer that friends said certain things about the bar, and the jury should disregard that. Proceed.
How long were you at Sonny's rooftop bar?
Well, we left right at 11:45 p.m. So we were there roughly 3 hours.
And what did you buy while you were there?
We got a couple wine glasses, some White Claws, and some green tea shots towards the end of the night.
Your Honor, we would like to ask for permission to share exhibits 11, 14, and 16.
Have these been admitted?
Yes, they've been shown through the. Yes, they've been admitted or pre-admitted.
These are pre-admitted exhibits. Mr. Morales, is that your understanding also?
Your Honor, that actually is not my
No.
understanding of what these exhibits actually are. I don't believe during preliminary matters, opposing counsel tried to enter any exhibits into evidence. I don't believe they actually even pre-marked the exhibits for identification. And no exhibit is currently in evidence, Your Honor.
Well, hang on a second. The exhibits are all pre-marked, right?
That's correct,
I have a
yes.
joint exhibit list so that they are marked. Go ahead, Ms. Boyd, you wanted to say something.
I misspoke. They're not pre-admitted, but I would like to constructively screen share them so that the witness could see them outside of the preview of the jury.
Ms. Levin, do you have a copy of all the exhibits?
Yes, I do.
Okay, so Ms. Boyd, you can direct the witness's attention to certain exhibits, but no displaying anything to the jury until something's been offered and admitted into evidence, okay?
Yes, Your Honor. Ms. Levin, do you recognize exhibits 11, 14, and 16?
Yes, I do.
Where do you recognize them from?
They're pictures I took of Jessica and our table on the night of March 24th, 2019.
Around what time did you take these photos?
I believe exhibit 11 was taken at 9:10 p.m., 14 at 10:18, and exhibit 16 at 11:32 p.m.
Your Honor, at this time, the plaintiff would like to admit exhibits 11, 14, and 16 into evidence.
Mr. Morales, do you have any objection to those exhibits being admitted?
No, Your Honor, it seems the foundation's been laid, so we have no objection.
So admitted.
Now, Ms. Levin, I want to direct your attention to a freeze frame of exhibit 10. Do you recognize this freeze frame?
Yes, it's a video I took on March 24th at Sonny's Rooftop Bar after Jessica had the drink she was served that night.
Around what time did you take this video?
I believe around 11:11 p.m.
At this time, the plaintiff would like to show a visual demonstrative for the help of the jury to get a visualization.
Mr. Morales, have you shown this, whatever this demonstrative aid is, to defense counsel? Has he seen this before?
No, Your Honor, but we can show it to them outside of the preview of the jury.
Okay, before we do that, is this an exhibit, a pre-marked exhibit, or is this a demonstrative that you've created?
It's a demonstrative that has been created by me.
Okay, so here's what we'll do. We will constructively dismiss our jury. We'll allow your second chair to display it. Mr. Morales will take a look. I'll take a look, and then we'll go from there. Okay?
Yes, Your Honor.
Great.
If my co-counsel could share that timeline. Miss Morgan, is this an accurate reflection of what had happened that night or the photos that were taken that night?
Ms. Boyd, let me just interrupt for 1 second. I'm sorry, I apologize. Mr. Morales, do you have any objection to this before we bring the jury back in and keep going?
No, Your Honor, it's perfectly in line with the testimony that the witness just gave, and I didn't have an issue with that testimony, so this is okay.
Okay, I'll bring the jury back in. Ms. Boyd, you can go ahead. I'm sorry to cut you off.
Is this an accurate reflection of the photos and the time that the photos were taken, Ms. Levin?
Yes, it is.
Okay. Miss, is there any objections to this?
No objections, Your Honor.
Yeah, I thought defense counsel said he had no objection to this, so I think we're good.
Okay. Miss Levin, is this an accurate or fair depiction of the time that the photos were taken that night?
Yes, they are.
I want to walk through Exhibit 11 with a visual demonstrative constructively out the purview of the jury, if that would be okay.
Okay, so we have another demonstrative that you want to show defense counsel. Okay, so I'll dismiss the jury again, and you can show it to defense counsel, and then we'll go from there, Ken.
Let the record reflect that my co-counsel is sharing Exhibit 11. Miss Levin, what's that drink in Jessica's hand?
Hang on a second, Ms. Boyd. I don't mean to cut you off again. This is a demonstrative aid that you wanted to show Mr. Morales to make sure he was okay with it. Is there anything else that's going to be on the screen aside from what we say here?
Yes, Your Honor. There will be icons for visualizing the drinks that Jessica had that night.
Okay, so this is what I think we need to do. Why don't you have your second chair display everything that's going to be shown to the jury right now? That way defense counsel can take a look and he can say whether or not he's got an objection to what the jury's going to see. So just is this the final form as to how it's going to look?
No.
Okay, so let's keep going. Let's keep displaying the rest of it.
That's it, Your Honor.
Okay, Mr. Morales, what is your position on this?
Your Honor, I would actually object 403, more prejudicial than probative as to this specific demonstrative. Your Honor, this demonstrative, all it does is show wine glasses or beer bottles or a can of beer to indicate how much Jessica had drank. Your Honor, it's not specific enough for there to be any probative value. All it is claiming Jessica Marks had these drinks. There's not much probative value to it, Your Honor. It quite honestly goes to waste the court's time.
May I respond, Your Honor?
Yes, please.
We're displaying this exhibit just to keep track of the drinks that Jessica had that night, as it can become very confusing, keeping track of what drinks were had by Morgan Levin and what drinks were had by Jessica Marks. And this is just a visual demo that would display the drinks that Jessica had that night.
Your Honor, may I be heard?
Ms. Boyd, were you finished?
Yes, Your Honor.
Okay, go ahead.
Your Honor, if you look specifically at this demonstrative, it doesn't give a specific explanation of what drink Jessica had, what alcohol concentration that drink was. It gives no specific details about what drink Jessica actually consumed. Your Honor, it's represented by an icon. For all we know, the jury could simply be guessing as to what that icon may mean. Your Honor, it's more prejudicial than probative because of the lack of specificity and, Your Honor, the general vagueness that is represented by this exhibit.
May I respond, Your Honor?
One more time and then I'm going to rule.
This demo is a reflection of what Miss Morgan knows. Miss Morgan doesn't know the alcohol content, and seeing that she doesn't know and I wouldn't be able to question her on that, I can't exactly specify the alcohol content as my opposing counsel would like me to. However, this document is more probative because it would reflect the testimony given by Morgan Levin, who watched Jessica drink those drinks that night.
Okay. I agree with Ms. Boyd, although your objection is well taken, Mr. Morales. To the extent that testimony comes out and you think something is being misrepresented or is misleading on this demonstrative aid based on the testimony that the witness gives, feel free to re-raise your objection. But at this point, I don't see anything on its face that makes this visual aid unduly prejudicial. So I'm going to overrule your objection, but allow you to re-raise that objection should you feel necessary. So let's bring the jury back in. Ms. Boyd, you can proceed.
If my co-counsel could go back to Exhibit 11. Miss Morgan, what's that drink in Jessica's hand?
It's a wine glass. She had 3 that night.
My co-counsel could move on to Exhibit 14. What's that can? The white.
That's a White Claw, and Jessica had 3 that night.
Miss Levin, what about that cup at the edge of the table?
That's a pint of beer that Jessica had.
And I want to display Exhibit 16. Miss Emile. Is there anything else on this table that Jessica didn't have or that has been displayed?
Well, towards the end of the night, we had some green tea shots.
Earlier, I asked you about a freeze frame of a video. Now, this freeze frame was taken at around 11 o'clock. Was this after Jessica had multiple drinks?
Yes, it was.
My co-counsel can remove the demo. Now, you have a copy of Exhibit 10. I would like to direct you to that. Do you recognize this video?
Yes, it's the video I took on March 24th at Sunny's Rooftop Bar after Jessica had the drink she was served.
And where do you recognize it from?
It was from that night after she had the drinks. I decided to take a video.
At this time, the plaintiff would like to move to enter Exhibit 10 into evidence.
Any objection?
Your Honor, there is no objection. However, my second chair is notifying me that time has elapsed.
Okay, Miss Boyd.
I'm sorry, I accidentally hit the 1 minute button too early. I'm doing 2 different things right now, so I'm trying to keep it on track.
Okay,
Your Honor, to the extent opposing counsel has a few issues with timing regarding their second chair, we're happy to give them a couple more seconds to finish the point they're trying to make.
okay. But understanding the time limits in this jurisdiction are pretty strict. Let's do that. You can have your 30-second grace period, and then we'll wrap this up. Okay.
Yes, Your Honor. At this time, the plaintiff would like to move to enter Exhibit 10 into evidence.
You have no objection to that, Mr. Morales, correct?
No, Your Honor, there are no objections from the defense.
All right.
Let the record reflect that my co-counsel is displaying Exhibit 10. Miss Emile, I don't think you shared your audio.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Was this the behavior that Jessica Marks was showing that night on March 24th?
Yes, her eyes were bloodshot. She smelled like alcohol. She had slurred speech, and she became very loud throughout the night.
No further questions at this time, Your Honor.
Gross,
Yes, Your Honor. May I proceed?
go right ahead.
Good morning, Ms. Levin.
Good morning.
On March 24th, 2019, Jessica Marks picked you up at around 6 p.m. I have that correct?
Yes,
The two of you went back to Jessica's Airbnb, right?
correct.
When the two of you got back to the Airbnb, Jessica started drinking. I have that correct?
Yes, we both had a couple glasses of wine.
The two of you left from the Airbnb to Sunny's rooftop bar, right?
That's correct.
Ms. Levin, just to be clear, after drinking at the Airbnb, Jessica decided to drive to Sunny's rooftop bar. That's correct?
Yes, and we didn't have any problem getting to the bar.
I'm not asking if the two of you might have had any problems getting there. Before Jessica decided to drive, she was drinking. That's correct?
Yes, we had one or two glasses.
And before the two of you left for Sunny's rooftop bar, you hadn't discussed who was going to drive home, did you?
No,
The two of you hadn't discussed getting an Uber?
at the end of the night, I decided to call an Uber, but not
Levin,
beforehand.
I'm not asking about the end of the night. Before you went to Sunny's rooftop bar, you didn't discuss with Jessica Marks whether or not to get an Uber. Yes or no?
No,
When the two of you got to Sunny's rooftop bar, you started drinking immediately, right?
we had a few minutes to ourselves, but then we started ordering some drinks.
Miss Levin, the two of you ordered several rounds, right?
Yes,
Your Honor, at this time, permission to screen share Exhibit 17 constructively outside the view of the jury.
This is not admitted, I'm assuming.
No, Your Honor, but it requires foundation based off the witness's testimony in order for it to be admissible.
I think the witness said previously that she's got copies of all the exhibits. Why don't you direct her attention to the exhibit and authenticate it that way, and then we can display it once if it's been admitted. Okay?
Yes, Your Honor. Ms. Levin, you recognize Exhibit 17 as your receipt from the night of March 24th. That's correct?
yes, I do.
It's a fair and accurate copy of that receipt.
Yes, it is.
Your Honor, at this time, defense offers Exhibit 17 into evidence.
Any objection?
Your Honor, this is hearsay.
Response.
Your Honor, this is hearsay. However, it's acceptable under the 803 hearsay exception of business records. Your Honor, the validity of this record has been validated because the witness testified it was accurate, and it's a receipt from a bar, Your Honor. It's something that happens in the regular course of business, therefore it's admissible.
Your Honor, may I respond?
Yes.
The prong that opposing counsel is referring to, or the exception, requires a custodian. And seeing that Ms. Levin isn't exactly a custodian in today's case, it would still be inadmissible under hearsay, considering that we don't have a custodian to actually certify that this is their regularly used receipt at the bar.
Your Honor, may I be heard?
One time, and then I'm going to rule.
Your Honor, opposing counsel is incorrect. We do have a custodian today, Sonny Maida. I expect Sonny Maida to testify, Your Honor, that this receipt is accurate and that he prints receipts, or rather she, in the course of everyday business. Your Honor, all the prongs will be satisfied in today's case. To the extent Your Honor doesn't feel he would like to let the exhibit in right now, I ask that you provide a limiting instruction. It is let in, and to the extent opposing counsel feels that prong has not been met, it may be removed from the record.
Okay, here's what I'm going to do. I agree with Ms. Boyd that you can't, you need a custodian to lay the foundation for that exception, or a certificate that satisfies the 803.6 prongs, which we don't have yet. However, given the unique setup of this jurisdiction where you can't call Ms. Mehta on your case, or we can't call Ms. Mehta in the plaintiff's case, I should say, I'm going to allow you to admit this exhibit now conditionally. But if we don't tie this up in your case in chief, I'm going to strike it from the record. Okay.
And Your Honor, defense is perfectly fine with that.
Okay. So that's what we'll do. So admitted conditionally, understanding that foundation is going to be laid later in the trial.
Ms. Levin, this is a fair and accurate copy of your receipt from the night of March 24th. That's correct.
Yes, it is.
Ms. Levin, you claim that the only drinks you had on the night of March 24th came from this receipt. I have that correct?
Yes, that's true.
Your Honor, at this time, defense would like to screen share a portion of Exhibit 26. Your Honor, this is the deposition of Stevie Rager, an eyewitness from the bar that night who was considered unavailable under Federal Rule of Evidence Code 804A.
Ms. Boyd, do you have an objection to that?
Yes, Your Honor. I don't believe that this is pre-admitted, and I object hearsay to this document.
Okay, Mr. Morales.
Your Honor, the hearsay, or rather the objection to hearsay, has already been satisfied. As I said, Your Honor, this witness is considered unavailable under hearsay exception 804A. Your Honor, the 804s are exceptions to hearsay for unavailable witnesses. The plaintiff actually stipulated that this witness was unavailable under that code of evidence, Your Honor.
May I respond, Your Honor?
Yes.
Though it may be satisfied by declaring unavailable, this document still has multiple evidentiary discrepancies, such as speculation, misleading to the jury. So we would ask that they share the portions that they would like to pull up, and we check over those.
Okay, before we get there, Mr. Morales, what are you intending to do with the transcript?
Your Honor, I intend on attacking the credibility of Ms. Levin during her testimony. Your Honor, I believe it's her claim that she only had alcoholic drinks from the receipt that she brought from the bar that night. However, there's eyewitness testimony to contradict that she only had those few drinks.
What I'm asking you is, what are you going to do during this cross-examination with that transcript?
Well, Your Honor, I'm going to confront Morgan Levin with that transcript, and then I'm going to attack her credibility based off the discrepancies between that receipt and what this eyewitness testified to during his deposition.
You're going to read her portions of the transcript and ask what question?
Well, Your Honor, I expect the transcript to specifically state Ms. Levin took shots of Fireball. Your Honor, I believe that's a form of liquor. There was no transaction listed on Exhibit 17 for a shot of Fireball. Your Honor, it goes to attack the witness's claim that she didn't just drink all the receipts on that, all the drinks on the receipt, but rather had other alcoholic beverages that were not listed that night.
Okay, I'm not going to allow you to read portions of another witness's testimony to another witness on their cross-examination. So you're certainly free to do that in your case, to read that transcript in and use that and submit that argument to the jury in closing arguments. But I think it's inappropriate to ask a witness on cross-examination about the testimony of another witness. So I'm going to sustain Ms. Boyd's objection in the sense that I agree that it's misleading at this point in the trial, and ask you to move on.
Yes, Your Honor. Now, Ms. Levin told us earlier that Jessica Marks had several rounds of drinks, right?
Yes, that's correct.
You also testified that the two of you left the bar at around 11:45. I have that right?
Yes.
Now, Ms. Levin, when you left the bar, you ordered an Uber. That's correct?
Yes, I did.
You ordered an Uber because you were scared to get in the car with Jessica. I have that right?
I ordered an Uber for both Jessica and I.
Well, Jessica never got in that Uber, did she?
No, she didn't. She insisted that she was fine.
Exactly. You actually asked her to come into that Uber with you. You said that verbally, right?
Yes.
But Jessica Marks had a reason for not getting into that Uber, didn't she? She actually told you, right?
Yes.
Jessica Marks told you, I've gotten pretty good at driving after a big night.
Yeah, but I found that to be a joke.
Okay, Miss Levin, I'm not asking how you may have found that comment. Jessica Marks said, I've gotten pretty good at driving after a big night. That's correct.
Yes.
And then right after she said that, she got in her car. That's correct.
Mm-hmm.
And she drove off.
Yes, she did. And a couple 100 feet, she was perfectly fine until she drove off the road.
Thank you. No further questions, Your Honor.
Okay, Ms. Boyd, I think you've run out of time, so we're going to excuse this witness. Thank you, Ms. Levin. Ms. Boyd, do you have any other evidence to put on or anything else to take up before you rest?
No, Your Honor.
All right. Mr. Morales, are you going to be putting a case on?
Yes, Your Honor, I'll be calling one witness during my case in chief.
Okay, whenever you're ready.
At this time, defense calls Sonny Maida.
Proceed.
Good morning.
Good morning.
Could you please introduce yourself to the members of the jury?
Hi, I'm Sunny Mehta.
Ms. Maida, at some point in 2017, did you purchase a business in Southern California?
I did. I purchased a small area of land by the Pacific Ocean and turned it into Sunny's Rooftop Bar, a restaurant and bar.
Ms. Maida, you just told us that you owned a bar. Have you been licensed by the state of California to sell alcohol?
I have. I had to complete numerous courses to get that certification, as well as my employees.
Have you taken any specific courses regarding how alcohol might affect the human body?
Yes, I've taken many courses to ensure that I can identify when someone is intoxicated, those specific symptoms, and then cut them off if need be.
Having been the owner of a bar for several years, would you say you're familiar with what an intoxicated person might look like?
I am, yes, that was part of the training.
Your Honor, or rather, Ms. Levin, or Ms. Maida, excuse me, do you recognize Exhibit 2?
I do, yes, that looks like Jessica Marks.
Was she at your bar on the night of March 24th, 2019?
She was at my bar.
Your Honor, defense now offers Exhibit 2 into evidence.
Any objection?
No, Your Honor.
So omitted.
Ms. Maida, did you see Jessica Marks with anyone at your bar on the night of March 24th?
I did. She walked in with her friend Morgan Levin and they began to order.
Ms. Maida, at some point during the night, did you make a comment to Jessica and Morgan about who was going to drive home?
Yes, I did. I wanted to ensure that Morgan Levin wasn't driving. She showed a few symptoms of intoxication. So I asked Jessica who would be driving that night, and she assured me that she would, and it would not be Morgan Levin.
No, Ms. Maida, did Jessica do anything to indicate to you that she knew you were speaking to her?
Yes, she turned to me and told me, no way, I'm driving, to assure me that it would not be Morgan Levin.
You just told us that Morgan Levin was exhibiting signs of intoxication. What signs was Morgan exhibiting?
She had bloodshot eyes. She slurred her speech a little. She stumbled a little. It wasn't enough for me to cut her off, but she definitely wasn't sober.
Ms. Maida, when was the last time you saw Jessica Marks on the night of March 24th?
I saw Jessica Marks leave my bar at around 11:45 that night, so that would be the last time.
Was she still with Morgan Levin?
She was. They both walked out of my bar together.
No, Ms. Maida, did Jessica say anything when she left your bar that night?
She did. She wished us good night and then walked out.
When she said goodnight, did she sound intoxicated?
No, she seemed completely fine. She wasn't slurring her words. She seemed like she had her faculties about her.
Was she walking in a straight line?
She was, yes.
At any point, did Jessica Marks come down the stairs?
She did on her way out of the bar, but that was the only time I saw.
Did she trip when she was coming down the stairs?
No, she did not.
How about Morgan Levin? How did Morgan Levin look towards the end of the night?
She wasn't completely intoxicated, but she definitely wasn't sober. She was stumbling a little. She had bloodshot eyes. So she definitely wasn't in the same position as Jessica Marks.
So, Ms. Maida, is it fair to say that Morgan Levin, for the entire night of March 24th, seemed more intoxicated to you than Jessica Marks did?
Yes, I would say that.
Thank you, Ms. Maida. I have no further questions, Your Honor.
Ross?
Yes, Your Honor. If you would give me 1 second to move about. Good afternoon, Ms. Mehta.
Good afternoon.
I want to start with you by asking you, you've been convicted of a crime involving lying, cheating, and stealing, right?
I've been
Objection, Your Honor, vague. And compound as well, Your Honor.
Overruled.
I've been convicted of a crime involving the possession of stolen property, but it was a complete misunderstanding.
Okay. Now, earlier on direct, you were talking about how you owned a bar and you needed certifications for this bar, right?
Yes, ma'am.
Specifically, you needed to be able to identify minors as a part of owning that bar, right?
Yes, that was part of the training.
But at some point, Sonny's Rooftop Bar received criminal charges.
I'm not sure what you mean.
Well, I'll rephrase. At some point, you signed a plea agreement, right?
I did in 2018, yes.
And this plea agreement was signed as a result of serving a minor?
Yes, a bartender of mine forgot to check someone's ID. I wasn't there that night, but I ran over and we did settle an agreement, yes.
Right. And as a result of this plea agreement, you had to purchase ID scanners, right?
We did, yes.
But you didn't use them on the night of March 24th?
No, unfortunately, they were broken, so our Amazon shipment of the new ones were not in yet, so I checked all IDs manually that night.
So that would be a no, you didn't use them on March 24th.
No, I did not use a scanner. I checked IDs manually.
Now, you were talking about the signs of obvious intoxication, but you also know about tolerance, don't you, Ms. Mehta?
Yes, ma'am. That was part of the training course.
You know that multiple factors go into tolerance, right?
Of course, the longevity of how much alcohol you drank in your life, the size, genetics, those all play into it.
Yep. Height goes into it.
Yes, ma'am.
Weight, right?
Yes, ma'am.
Time, right?
Yes, all of those.
That night you were aware that Jessica was really short, right?
She seemed short to me. I didn't know her height, but she looked to be about 5 foot tall, yes.
And she was small to you?
She seems pretty small, yes.
And she'd been drinking at your bar for around 3 hours?
I wasn't sure if she was drinking, but she had been at my bar for 3 hours. Yes, ma'am.
Okay. But you did serve drinks to their table, right?
I served them to the table, yes.
Okay. And you were the one clearing their table, right?
I was, yes.
Okay. I want to direct your attention to something that's already been admitted into evidence. Specifically, you were here for when we played the video on direct of Morgan Levin.
I did see that, yes.
Okay. Let the record reflect that my co-counsel is now screen sharing what has been pre-marked as Exhibit 10.
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
Miss Mehta, you're aware that this video was taken in your bar.
It looks to be, yes, ma'am.
You're aware that you had served around 7 drinks at that time to that table.
I did serve those drinks to that table, yes, ma'am.
Oh. I want to talk to you about one of the comments that you made at the end of the night. As you said on direct examination, you said you hope this one's not driving, right?
Yes, referring to Morgan Levin, as she did not have her faculties about her.
Okay. But you didn't stop serving Morgan Levin at that point, did you?
No, I didn't think she was clearly intoxicated to the point that I needed to cut her off, but I didn't want her driving.
But correct me if I'm wrong, Miss Mehta, you just said she didn't have her faculties about her.
Yes, ma'am. She wasn't completely sober.
Okay. I want to talk about when they left your bar. You're aware that she crashed after she left your bar?
I did. I heard that on the news the next day.
You're aware that she was found with a blood alcohol content of 0.16?
I heard that, yes.
You're also aware, as a bar owner, that the legal limit for an adult is 0.08.
Yes,
Right.
ma'am.
And you're also aware that the legal limit for a minor, like Jessica, is 0.01.
Yes.
No further questions at this time, Your Honor.
Redirect.
Yes, Your Honor. Ms. Mehta, on the night of March 24th, 2019, how many times did you visit Jessica Marks's table?
I probably went there 8 or 10 times at most, taking their orders, maybe 4 or 5 times, and then coming back with drinks.
Did you interact with Jessica while you visited her table?
A little. I spoke to her about the drinks that she was ordering, but it wasn't a long time, maybe 20 or 30 seconds at most.
Did you ever see her stand up and fall down?
No, I did not see that.
Did you ever see her throw up?
No.
Did it seem like she wasn't making sense to you?
No, she seemed like she was able to order her drinks, and she seemed fine to me.
Thank you, Ms. Mehta. No further questions, Your Honor.
Mr. Morales, do you have any other evidence?
No, Your Honor. At this time, the defense rests. We're ready to proceed to closing arguments.
Okay. Ms. Boyd, are you ready to proceed to your closing?
Your Honor, may I have a 5-minute recess to get my thoughts together for closing
Okay.
argument?
We're not going to take 5 minutes, but why don't we take 90 seconds?
Yes, Your Honor.
So let's take a 90-second break and then we'll get going.
Thank you, Your Honor.